We're going to talk for the next hour about the Supreme Court's business docket. And I was bemoaning the fact during the earlier panels that we just don't have those same kind of facts with blood and knives. And, you know, it's just not as riveting. But certainly this panel will try and give you a lot of great background on the cases that you'll be able to watch this term and to kind of review some of the big legal principles that we think are going to be decided. The biographical background of the panel members are in your binders, of course, but I'll tell you that really this is just a panel of repeat players. These are the folks who argue cases before the Supreme Court on a regular basis and have background generally in the Solicitor General's office, and also are leading the appellate practices at their respective firms. I actually am a government lawyer at the moment. I do have to say that my opinions, if I express them, will be of my own and not of the government, that all of these folks understand. When we sat down to put the panel together, we looked through the cases that are in your binder, and we'll be talking about several of those. We'll be talking about a couple that aren't in there as well. And business cases, to me, are never so easily categorized as criminal cases. You know, you have Fourth Amendment cases in criminal law, and Fifth Amendment cases and sentencing cases, but it just doesn't happen that way with business cases. So it's a little more difficult sometimes to find common themes. What I thought we'd do is start out with a couple cases in the securities area that Tom Goldstein's going to talk about. At the end, we're going to come back to some labor and employment cases that Glen Nager is going to talk about. And then in between, we're going to have both Carter and Greg are going to talk about preemption, which you've already heard about, and we'll get to in a bit. So with that, I wanted to thank everybody for being here and thank us for having here, and turn to our panelists. We have one extra panelist on our group, so we're going to try and squeeze a lot in the next hour. Tom Goldstein is head of litigation at Aiken Gump, their Supreme Court practice. He started, and of course, as mentioned earlier this morning, was the founder of SCOTUS blog that I dare say everyone in this room has gone to at one time or another, and some on a regular basis, daily, perhaps hourly. Tom is going to start off, as I mentioned, with a couple securities cases, which in and of itself is unusual because there aren't that many security cases on the Supreme Court that often. And I just want to clarify that as opposed to the Prison Litigation Reform Act, the PLRA we're talking about, one of Tom's cases involves the PSLRA, the Private Securities Litigation Reform Act. And then if he has some time, he might talk about a copyright case also.
Thanks so much. So here are the rules. These are cases under the securities laws. And let me tell you what they say, and as it applies to the two cases that I'll talk about under that involve securities. So Rule 10b-5, issued by the SEC, makes it, quote, unlawful for any person, directly or indirectly, to make any untrue statement of material fact or to omit to state a material fact necessary in order to make the statements made not misleading in connection with the purchase or sale of a security. And the Supreme Court, in a case called Stone Ridge, recently said, all right, here's the basic set of things that you have to prove in order to make out a securities case under 10b-5. In a typical 10b private action, a plaintiff must prove 1, a material misrepresentation or omission by the defendant, 2, scienter, that is, you were doing it kind of on purpose, 3, a connection between the misrepresentation or omission and the purchase or sale of a security, 4, reliance, 5, economic loss, and 6, loss causation. So we have two cases that present the question of who are the people that you can sue for securities fraud, and second, what is it to make a material misrepresentation or omission? So we'll do the who case first. It involves a mutual fund. It involves Janus, and a Janus affiliate, which is in a separate company called Janus Capital Management, and it's consistent with Beth's desire that this be kind of on a par with individual rights cases. Imagine that someone from Janus Capital Management has secretly murdered. No, I can't do that.
Secretly lied about.
Right, and there's DNA. Sadly, the case instead involves the question of the relationship between an investment fund, a mutual fund advisor, and the mutual fund. So the idea here is that Janus was involved with the sale of its securities in market timing. You may remember the market timing disputes about whether or not certain transactions were lawful. And eventually, Janus ends up losing a bunch of money when people pull out of Janus funds because Janus was engaged in market timing, and then people sue. Investors in the mutual funds sue because the mutual funds lose money. And the question is, okay, we know that you're going to try and go after Janus, but can you go after Janus Capital Management, JCM, which is the advisor? The complaint alleges that JCM is effectively, though it's a separate corporate affiliate, is really managing the fund and is responsible for the statements by Janus that it is not engaging in market timing. They allege that the fund is responsibly managed and the like. And so the plaintiffs want to go after not just Janus, but go after Janus Capital Management. So you can look at the case narrowly as one about investment funds, but the business community is often concerned about other efforts by the plaintiff's bar to bring in other third-party advisors, and the plaintiff's bar and folks who are the victims of securities fraud want to go and get the other advisors as well. And so you can imagine cases in which banks get sued for being involved in statements by people who run funds, or God forbid, and this part would be unconstitutional, lawyers being sued for advising their clients and being involved in prospectus statements about investments. And so the Supreme Court in general has been hostile to the idea that you would go after third parties rather than the actual person who made the statement. The question here is the relationship between the investment fund, at least as alleged in this case, case was dismissed at the outset. The complaint alleges that the investment fund advisor was very directly involved in the prospectus of the mutual fund, that the people who read the prospectus would understand that JCM was responsible for it. So what kind of relationship is required between a third party and the actual corporate party that's issuing the statement about the investments in order to hold them liable for securities fraud in making a misstatement of some kind, here a misstatement about market timing? The second case involves the question of materiality. So remember, you have to have a misstatement or an omission, but it has to be material. And this is a case, that one was the Janus case. This is the Matrix case.
This is in the materials at page 170.
And the Matrix case does not involve Keanu Reeves at all. The Matrix case involves Zycam.
So we wish it did.
It would be much more interesting, and there would be better graphics in my presentation. So the Zycam, I don't know if you remember Zycam. Zycam was a big hit for a while, a kind of homeopathic remedy. You would stick a Q-tip up your nose, and you would be protected from every disease, or at least colds. You would swab your nose, and magically nothing would ever happen to you. And you'd win Publishers Clearinghouse. It was amazing. So Matrix got reports of anosmia. Anosmia is the loss of your smell. And Matrix would respond, well, that stinks. But Matrix sold millions of these Zycam kits, millions of them, and got roughly 1 or 2 what are known in the FDA world as adverse event reports. So they get these reports in, which they have to disclose to the FDA, that says somebody says that they lost their sense of smell after taking Zycam. And the makers of Matrix reacted, we're going to study this or whatever, but we're not convinced that the millions of packages of Zycam are causing people to lose their smell, because you take Zycam when you have some sort of cold or upper respiratory problem, and having an upper respiratory problem is also a cause for you to lose your sense of smell. So getting 12 to 24 we don't think is sufficient to disclose to the marketplace. So remember, this is a securities fraud case. The question is whether Matrix had a material omission. It didn't tell the market something that would contradict its statements to the market that, hey, we're doing great, we're selling a lot of Zycam, and the company's doing really well, and we think the stock will do really well. If they had instead said, yes, we're selling a lot of Zycam, but we're causing everybody to lose their sense of smell, and we're going to be exposed to billions of dollars in liability, it's possible that something would have happened to the stock price. But Matrix faces a dilemma. At what point in time do they take these adverse event reports and disclose them to the market when they may mislead the market, right? What is the rule for deciding that something is material or not? And so the test that Matrix advocates for is statistical significance. That you have to, when you're doing anything involving, I'm a lawyer, I have no idea, but somebody says in the briefs that a statistician won't tell you anything, but a statistician will tell you that you have to separate the wheat from the chaff, the noise from the actual events that you can show are causative rather than just correlative, that 12 to 24 is not enough in millions of packages of Zicam to say there's really a reason to believe that we may be causing this problem. So they get sued, and the Court of Appeals here says we don't care that standing alone the number of adverse event reports was not statistically significant. The plaintiffs have stated a claim that you had to disclose that to the market. And so the Supreme Court's going to decide in this kind of context, is materiality for an omission or a false statement, does it require that you actually, that it be statistically significant?
Let me ask you one question. Do you think that why do you think the court took these cases? It's interesting that they don't take that many securities cases, and do you think it has anything to do with the economic crisis, kind of, the feeling in the country about need for perhaps more oversight in some areas? Were there clear circuit splits in these cases?
There were semi-clear circuit splits, so that in the first case, Janus, the court sent the case to the Solicitor General saying, figure this out for us, give us some advice on whether we should get involved. The Solicitor General said stay out because the complaint here makes allegations about a very tight relationship between the advisor and the mutual fund. And while there are cases that require a pretty bright line separation, those don't involve mutual fund in order to, that require a quite tight nexus before you can hold the advisor liable for the statements of the principal. Those are cases involving lawyers and bankers and stuff like that, and mutual funds are different. But it did seem that there was a different legal standard that was being articulated. And in Matrix, the Court of Appeals here had quite explicitly rejected a rule that seemed to be applied by other circuits that required statistical significance. So I think this was kind of the classic, we've got to get involved because there's a difference in the Courts of Appeals. I will also say that I think that these cases tended to be leaning in the plaintiff's direction, whereas the Supreme Court has tended to lean in the defendant's direction in the 10b-5 context, and that might have put an extra bit of weight on the scale.
Okay. We'll save the copyright, maybe come back at the end of that. Next person we're going to hear from is right next to me, Garre. He is currently chair of the Supreme Court practice at Latham & Watkins, but I do have to point out that he is a former assistant to the Solicitor General, principal deputy to the Solicitor General, and former Solicitor General himself. So he comes with a lot of government experience as well as his current firm. And Greg is going to start our conversation about what I find is one of the most interesting areas of the Supreme Court dock, and it's preemption. That's really the relationship, as most of you know, between federal law and state law, and what state law, whether it's a state statute or state cause of action, go forward, notwithstanding some aspect of federal law that also regulates in the area. So he's got a couple cases he's going to talk about, and they're much in the old days. Preemption law was always developed in ERISA cases. It's very nice that we've moved away from that. He's got some minivans, vaccines to talk about, so that'll be good.
Great, thanks very much. So I think the preemption cases are usually quite important from a couple of different perspectives. First of all, from the business perspective, they're often very important because oftentimes what it means for businesses is, are we going to be governed by one federal rule that we can rely on in making our products and selling our products in 50 different states across the country, or are we going to be subject to individual state tort actions in the various 50 states across the country and be subject to potentially very significant damages awards. So oftentimes in these cases are very important to business, and you see the typical business groups lining up. The other way in which they're very important is from the constitutional perspective. Questions of preemption ultimately boil down to questions of the balance between the federal government and the states, and the preemption doctrine itself is grounded in a specific provision of the Constitution, the Supremacy Clause, which was debated heavily at the founding, and ultimately the founders decided that federal law should be supreme in our republic. And so in any of these preemption cases, no matter how sort of obscure the area or idiosyncratic the underlying dispute. I mean, ultimately, it boils down to a question of the relation between the powers of the federal government vis-a-vis the state, something where the nation has struggled for 200 years. This term's cases, I think, are very interesting for a few reasons. One, this is an area of law where Justice Stevens has left a remarkable mark on the court's precedents. If you go back and you look at the major preemption cases over the last 2 decades, almost invariably, Justice Stevens is writing the majority decisions in these cases when the court is finding that laws, that suits are not preempted. And in many of the cases, including one we're going to talk about later, Justice Stevens is the one writing the lead dissent in cases where the court is finding that there is preemption. So now that Justice Stevens is left, the big question is, where is the court going to go on this, and how much of the court's doctrine was really tied to Justice Stevens' genius in pulling together majorities. Another reason why this is an interesting area to follow is it's an area in which you have oftentimes unconventional lineups. Justices don't break into the sort of cookie-cutter conservative liberal blocks here. Justice Thomas, for example, is someone who consistently votes in the no preemption camp, which you might view from a 10,000-foot perspective as an anti-business perspective, and someone might see him as a justice who would be sort of more pro-business. But he's sort of made clear that, generally speaking, he's not a huge fan of preemption without the clearest indication of Congress' intent that that's what Congress wanted. And so almost all these cases, you see him voting with the liberals. Conversely, you see Justice Kennedy as a typical swing vote, and he is here. And also Justice Breyer is someone who often will vote with the pro-preemption camp. So he's something of a swing justice, even though you might sort of put him in the more liberal camp for other areas. And the other reason why this is an interesting area of law to follow is that we've got 2 new justices on the court, Justice Sotomayor and Justice Kagan, and we really have almost no idea where these justices are in the area of preemption, and particularly since preemption has produced such interesting outcomes from the perspective of individual justices. I think from the standpoint of a new justice coming on the court, this is really one of those areas where the justices kind of have to just figure out their own doctrine as they develop on the court. So that's an interesting thing to watch as well. So this term, there are 4 preemption cases pending before the court, and they sort of fall into 2 different categories: express preemption and implied preemption. Express preemption involves situations where Congress explicitly says in the statute, these suits are preempted. It sort of boils down to a question of congressional intent. Implied preemption involves cases where the debate isn't over whether Congress said this, the debate is over whether the state suits would sort of interfere with federal objectives in a more broader, more abstract sense. And it's really implied preemption or conflict preemption that's been the subject of recent attacks in the court, and where many think that the court is going in a direction where it wants to sort of get out of the conflict preemption business and rely more on express preemption. And so the first case I'm going to talk about today is a case called Williamson versus Mazda, and it tees up the conflict preemption issue for the court in a really interesting situation. And so just to lay out the case generally, let's suppose, and this will be scary for those of you who know me, let's suppose that I'm the federal government or I'm the federal administrator, and my job is to decide classroom safety and decide things like how people should get out of classrooms and the like. And so I've studied the question, and I've decided that there are really sort of competing trade-offs in whether people should leave from the right-hand door or the left-hand door. I'm not going to mandate that people have to leave through one particular door. Instead, given the trade-offs, I'm going to issue a rule. I'm going to say, after stat class, students or participants can leave through either door. And so after the seminar is over, you get up and you leave through whatever door presumably is closer. And those of you who happen to exit through the left-hand door are greeted by our friendly police officers from Williamsburg who arrest you from leaving out the left-hand door. And you say, well, wait a second, I thought the federal government just told me that I could leave through either door. How can it be that I'm getting penalized for leaving through that door? And that's kind of like the question presented in the Mazda case, at least from the automobiles manufacturer. The federal agency that regulates motor safety has told motor vehicle manufacturers explicitly in a rule for the rear center aisle seats of cars. Think of a minivan, you have the middle row and you've got a center seat. And think of who usually sits in those seats. the most frequent occupant of that seat is a child. For those seats, we're not going to mandate during the time period in question, a lap shoulder belt, the sort of belts that we're familiar with. And we're going to let manufacturers choose between the lap shoulder belt or the lap only belt, which is something of a historical anachronism today, but at the time in question, 1989, 1993, was manufacturers had the option. And so this case involves an automobile manufacturer who's being sued by the family of a woman who was tragically killed in an accident where she was she sat in a seat with a lap-only belt. And they're suing under California tort law, saying that the vehicle was defective because it included a lap-only belt and not a lap shoulder belt. Well, this case, one of the reasons why it's interesting is it follows on the heels of a case the Supreme Court decided about 10 years ago in a very similar setting called Garre. And in Garre, the question was how to interpret the airbag rule, a rule that gave manufacturers the choice of installing an airbag or a different kind of passive restraint system at the particular time in question. And in that case, there was an accident, and the drivers of the accident, people who were harmed, sued, claiming that the vehicle should have been required to have an airbag. And the Supreme Court held that that suit was preempted because the federal government had given manufacturers the option between having an airbag or a different kind of system. And in that case, Justice Breyer wrote the decision for the court. It was a 5-4 decision. Justice Stevens wrote the dissent in that case, saying that there was no preemption. And so now the Supreme Court takes this case almost 10 years later, and the question is, well, how is the case going to come out? I mean, in one sense, and I should have disclosed earlier, I represent the automobile manufacturer in this case, so my apologies for that. In one sense, our position certainly is, well, this case follows directly from Garre. You've got a rule. It gives manufacturers an option. The reason why the federal government gave manufacturers an option was to serve safety objectives, because there were trade-offs between perhaps the shoulder belts were safer for adults, but the most likely people who sit in this seat are children, and shoulder belts are okay for children as long as they're in a booster or a car seat. But guess what? At the time in question, 99% of the children sitting in those seats didn't have boosters, and they didn't have the right kind of car seat. And if you're a child and you've got a lap shoulder belt and you're not in a booster seat, guess where the shoulder belt goes? It's sort of like a neck belt, and that's not so safe for children. Similarly, installing the lap shoulder belt requires anchoring something to the side of a vehicle, and when you put the strap over there, that was an easier way to do it. It can create problems for people getting in and out of the vehicle. So there were policy reasons why the agency had this rule. And so our perspective is, well, look, if it was true that the rule in Garre was preempted, then the rule in this case ought to be preempted. So in one sense, what's interesting about this case is Garre was a 5-4 case. Stevens was in the dissent there. The plaintiffs in this case are really, some of their lead arguments come straight out of the dissent in Garre. So if the court were to rule for the plaintiffs in this case, one could look at the decision and say that this is a real example of where the Supreme Court's law is changing in preemption and a concrete impact, even if it didn't explicitly overrule the Garre case. Implicitly, I think it would signal that the court is moving in a different direction on conflict preemption issues. Now the plaintiffs in this case, to their credit, they argue that, well, look, what Garre was about was a policy of encouraging a mix or a variety of different passive restraints. The government had very specific reasons about how it wanted to phase in airbags, and so the suit in that case would have conflicted with that objective. And here they argue you don't have the similar kind of mixed or variety objective, even if you have all the other safety or technical feasibility objectives. So that's one thing that will be tested too. Justice Kagan is recused from this case because the government is involved in the case. They are representing the plaintiffs in the case, saying that there is no preemption. So one possibility in this case is that you will have a 4-4 tie, which will make no new preemption law, but leave the lower court decision in this case, which found preemption on the basis of Garre, in place. Let me talk very briefly about the express preemption cases. There's 3 of them, and I said the question in this case is how clear, in these cases, how clear does Congress have to be when it has these express preemption provisions? And so in each case, the court is going to look very carefully at the express preemption provisions. But I also think in each case, the backdrop of the area of the law that's involved is probably going to have a significant impact on how the court comes out in these cases. The first case arises under the National Childhood Vaccine Act, and that act created a no-fault system whereby you had a special vaccine court. The federal government would list specific vaccines that were covered, and the parents of children who were harmed by those vaccines could go to the vaccine court and get monetary awards. The cost of having that system was a preemption clause that Congress included, which said, no vaccine manufacturer shall be liable in a civil action for damages arising from a vaccine-related injury or death if the injury or death resulted from the side effects that were unavoidable, even though the vaccine was properly prepared and had the proper warnings. And so the plaintiff in this case says that, well, the preemption clause doesn't preclude us from going into federal court and say that this harm, this injury that the child tragically suffered was avoidable, and so we can litigate that. And the drug company on the other side says, and supported by the United States, says, well, wait a second. If you can go in and test the avoidability of these side effects in federal court, that's going to defeat the whole purpose of the federal preemption clause, and it's going to take down the whole system for protecting those who manufacture vaccines, which was based on a very compelling health purpose of ensuring that companies can rely on the fact that they can produce these vaccines, which have had remarkable health benefits for the nation, without being worried about being hit with million-dollar suits in the tragic cases where children are hurt. So there's an instance which I think that the fact that it involves vaccines and helping children and the very strong policy objectives, even though it doesn't technically go to how you would read that preemption clause, I think it could well impact how the court approaches that case.
Greg, why don't we, I think, just jump to Carter for a couple minutes. He's got preemption cases too, and you can comment on that. I think that his cases dovetail quite well with the ones Greg was just talking about.
The two cases I'm going to talk about, one has come up previously. I think it was in the individual rights group. That's the Chamber of Commerce case. And part of the reason I'm going to talk about it is because it's my case, so I'll disclose that at the outset. And then I'll just give you some additional context for the case, because I think it's a pretty interesting problem. And then I'll talk about the AT&T Mobility case, which is the arbitration, which is, these are not sort of what you might think of as kind of core preemption cases, although they do raise precisely the point that Greg made, which is the relationship between explicit or express preemption and implied preemption and how that plays out. And at least from my perspective, the sort of single most interesting aspect of this will be to watch what Justice Thomas does in connection with this, because he announced already that he is not going to entertain implied preemption claims. Now, whether he really believes that or not, I don't know. This is going to be a real interesting test, because there's some pretty compelling implied preemption arguments that can be made in a number of these cases, and whether he will then stick to his guns and say, I'm just not going to think about it in those terms. And what I don't remember is, was he in the majority in Garre? Okay. So you don't have to worry about him there. The Chamber of Commerce case, as I say, it's already been discussed a little bit, so I won't spend too much time on it. Obviously, there are two issues in that case. One is a pure express preemption question, and that's the provision says that states are not allowed to sanction employers for hiring illegal aliens, save through licensing and similar laws.
This is the case out of Arizona again
This is the
that was
Arizona case,
talked
right.
about before.
And so it is a what would appear to be a relatively narrow exception, and I know that folks who talked about it before described it in those terms, and it is a strange notion that you could just adopt a quote licensing law that is just specific to the immigration context, as opposed to licensing people who do haircuts or whatever else you do, and then taking into account some aspect of that. It also seems a little peculiar to imagine that the states can create an entire scheme of parallel regulation and enforcement so that they can determine whether or not you have violated federal law and then punish it in a particular way, as opposed to what might be the more realistic way of reading the statute, which is to say, if in fact the federal government has made a complete determination that you have violated federal law, then it is available to you to add a sanction beyond that, so long as you use it, as long as you do it through a licensing mechanism. from my perspective, in terms of just as an advocate, the difficulty is just trying to figure out what does it mean to be a licensing or similar law. I mean, I think it's pretty easy to debunk the Ninth Circuit's notion that simply because it uses the word licensing, that means it's a licensing law. I don't think that's likely to get a whole lot of support out of the court in terms of how to interpret the statute. But coming up with a limiting principle on my side has been at least a challenge. I commend our brief to you at some point if you want to read how to deal with a challenging exposition of what might be viewed as broad language and trying to come up with a way to impose some limitations on that. The second issue in the case then is the E-Verify portion of it and the fact that the federal government has always made it voluntary and the states have made it mandatory, or at least Arizona has made it mandatory. And there, the Ninth Circuit concluded that making it voluntary at the federal level doesn't necessarily say anything about whether it has to be mandatory at the state level, although obviously if all 50 states adopt a mandatory approach, you will have a mandatory national system of E-Verify. What's kind of interesting about the two issues, and it goes to the question of the parties that are involved in it, because you've got the Chamber of Commerce, labor groups, and civil rights groups, and they are not natural allies, as I suspect you would have assumed. And they have a little bit different take on which portions of it particularly upset them, because the Chamber is probably more agitated about the E-Verify part of this, because that imposes very significant burdens on how every business does its hiring on a regular basis, and some inconsistency. So if you have a national program, you're going to have to modify it for hiring you do in Arizona and perhaps other states as more of this legislation comes into being. Whereas, not surprisingly, the civil rights groups, to some extent the labor groups, are more concerned about the sanction, because their fear, which you might say, well, why wouldn't the employers be fearful of the sanction? And the reason is because they can pretty much avoid the sanction simply by hiring people who don't look to be aliens. So they've got a pretty easy out in this context, and so not surprisingly the civil rights groups are saying, well, yeah, that can't be the right answer. And Congress is quite clear in the statute, because it not only has the provision in dealing with sanctions on employers for hiring illegal aliens, it also adds another sanction for discriminating against employable aliens. And they are, interestingly, absolutely parallel provisions. So there is as much risk in going in one direction as there is in going the other direction as a matter of federal law, which suggests that Congress intended very much for this to be essentially a federal scheme. So it will be very interesting to see. The express preemption provision, I think you can read it pretty consistently with the way the petitioners want to. The government is certainly supporting that interpretation. The trickier part is that the second half of that, the question of whether Congress' decision that it should be voluntary creates a conflict for a state system, that's going to pose, I think, squarely to the Justice Thomas problem. Because to me, it is fatuous to think that Congress really meant to leave the states free to do what Arizona is doing here. But we'll see how Justice Thomas weighs in on that particular case.
On that point, I think it's part of that implied conflict preemption is often called frustrate the purpose, and that's what Justice Thomas disagrees with specifically, and yet you have a scheme that Congress has set up, and something's going to completely frustrate the purpose of that. It will be very interesting to see where he goes. Tom had a question for you, Carter.
So, Carter, do you have a sense of the relationship between this Arizona immigration case and the one that everybody's been talking about for the last 6 months? Like, yeah. What will mean, the first one will mean for the second one?
Yeah, well, I mean, there are two things. First of all, I think it's reasonably clear, given the sequence of events that happened, that the most recent Arizona statute probably had as much to do with the court granting certiorari in our case as anything, because this was a case that had been pending before the Solicitor General Hagan at the time, and had been pending there for a very long time, and then Arizona passes a new statute, which I think gave a significant amount of impetus for the federal government to take a hard look at immigration issues generally, and explains, at least in some measure, why the government came in somewhat more on our side than I think we might have predicted at the beginning. In terms of the real question that you asked, Tom, and as far as the relationship between the two, certainly the express preemption provision has no particular significance to the second litigation. The question of the relationship between federal and state law and what the kind of working assumption and context is, that will have substantial importance for the second case. And
Right, so if the Supreme Court comes along and says immigration is a really federal
Federal.
thing, and, Congress has really got this field covered and the state shouldn't be piggybacking on it, or on the other hand, if it says it's, they're just picking up another remedy for
Right.
whatever wants to say.
Yeah, so I do think it will say a lot about how that second case will come out, although it doesn't necessarily have to, depending on how the court, they could certainly write around it in order to preserve that second case.
I should just point out, the other case is pending in the Ninth Circuit right now and in the district court. The United States sued. We filed a brief on Thursday night in the Ninth Circuit where Arizona had appealed from a preliminary injunction that enjoined certain provisions of the second Arizona statute. So that'll be going on in the lower courts as this case is litigated in the Supreme Court, which makes it all the more interesting.
Yeah, the other thing I was just going to say about this case, because it doesn't really have anything to do with sort of what's going to happen going forward, but it's just an interesting case study in the certiorari process. This is a case where we did not have a conflict in the circuits. There have been 3 Court of Appeals decisions now that have come down on the question of the extent to which the states or local governments are allowed to regulate immigration generally in the employment context. One of those cases came down very recently in the Hazelton decision, but prior to that, the 10th Circuit had come out with a hopelessly muddled 3-judge panel decision that goes off in 3 different directions in reviewing preliminary injunctive relief. And so we could not, with a serious message, say to the court that there is a conflict in the circuits, or even that there's necessarily likely to be a conflict in the circuits. And so what we did do was expressly ask the court to ask for the views of the Solicitor General. And the reason we did that was in part because the President had expressed doubts about states and localities regulating in the immigration area, and in part because the executive branch had assiduously avoided taking a position on the relationship between federal and state law in the immigration context. And as we sat there are literally hundreds, if not thousands, of state and local laws being adopted, and certainly even more than that being considered, because there is this concern that the federal government is left as void. And so we made as an explicit a pitch as I've ever made to ask the court to get the SG involved. The court did do that. I do remember now Justice Kagan's first comment to me as she walked into the room, which was, thank you for asking the court for our views in this case. And then she rolled her eyes because it was pretty clear that she was not all that anxious to actually express her views. Obviously, since she participated in the internal deliberations at some length in our case, she will not be involved in it, which of course creates the very real anxiety about whether or not this ends up as a 4-4 decision and the Ninth Circuit gets affirmed. But I'm not going to think about that real hard at this point, at this stage. I'll worry more about that after the oral argument. The AT&T mobility case is a very interesting problem. Arbitration has been a subject that the court seems to just delight in taking cases in. They had 2 last term. I think they had 2 the term before that, 3 the term before that. There is a pretty clear consensus among at least the majority of the justices that arbitration is a good thing. And it's a less expensive and simple way of trying to resolve disputes, and probably more to the point, it gets cases out of the court system, and that's a good thing in its own right. The issue that has been percolating up is, what do you do with this notion of class action arbitration? And the reason it's been percolating up is that part of the reason why business community loves arbitration is it's a one-on-one deal and it's not very expensive. And if you make a mistake that affects a whole lot of different people and you have an arbitration clause, in theory you can evaluate each of those cases seriatim individually and blissfully out of, if you've made a mistake that involves 50,000 people, you're probably only going to get about 50 to 100 who are actually going to raise any ruckus about it, and life goes on. On the other hand, if you if the plaintiff in any of those cases can convert those $3 and $5 or $30 claims into tens of millions of dollars of claims by aggregating them through the mechanism of a class action in arbitration, well, then that's a very different problem. And it's exacerbated by the Supreme Court's intervening decision in which it says that the parties aren't free to modify the standard of review when the court is entertaining a challenge to an arbitration award. So the standard of review is very lenient in terms of upholding arbitration awards. So if you are a business and you get stuck with a $25 million arbitral award arising out of a class action, the likelihood that you're going to be able to get that tossed aside is not that great. I think it makes this whole dispute kind of interesting is that obviously arbitration is by its nature contractual in nature. It is typically something where the court tries to enforce the contracts as written. And the reality is that there is no one who would ever write a contract, at least no business that's ever going to write a contract that actually expressly makes provision for a class action arbitration, if for no other reason than because it's almost impossible to know how that would be enforceable. That is, you don't know how the notice is going to play out. There are no rules that really are going to completely guide you through this process, and there's no assurance that the class determination will ultimately be binding on any of the non-participating class members. You have protections in the state and federal system in class actions, but the same protections candidly don't exist in the ordinary private arbitration setting. So it is a very difficult situation to grapple with. And there have been a number of sort of what you might call side bet skirmishes. The court dealt last term in Stolt-Nielsen with the class action arbitration and said we're not going to read into these agreements a provision of class arbitration. And indeed, the court rejected a decision from 7 or 8 years ago where it sort of left open the question of whether they would allow arbitrators to find class actions to be implicit in a contract. And I should say out of full disclosure that the case that was 7 years ago was a case that I ostensibly won but felt like I mostly lost, and the court has now 7 years later gotten it right in terms of how to approach that issue. But the much more fundamental question, which is the Concepcion case this term, is can the states rely on the language in Section 2 of the FAA, which says, generally speaking, all courts should enforce arbitration agreements save upon such grounds as exist at law or in equity for the revocation of any contract. Okay, so this is another one of these exceptions cases. You got a fairly broad federal rule, but then there's this exception. What do you do with it? Well, unconscionability has been long regarded as a ground that exists in state law for revoking a contract. That is, if you enter into it and the state court determines that this is an unconscionable contract, it is revocable under those circumstances. And so then the issue is, well, what if the state declares that all arbitrations that don't make provision for class action are, in fact, unconscionable? And in this context, the state law, California law, says it's unconscionable procedurally because it's a contract of adhesion, and it's unconscionable substantively because it's largely exculpatory. That means it's set up, the arbitration is set up in a way that's designed to as I said earlier, if you got 50,000 claims, you want to litigate maybe 20 of those claims. That means 49,980 other claims are going to get lost, and the clause that denies you the right to have a class action is exculpatory as to all of those parties, and therefore, as a matter of state law, common law, contract law, and conscionability, that's an unacceptable and unenforceable agreement. And that's how California has come out, and then so arbitration in California is subject to serious question going forward. AT&T did something that was very interesting. They decided to write as consumer-friendly an arbitration clauses as they could possibly, I was going to say stomach, that's probably not the right way, but that they thought would sell. That is, they have in it that if we make you a settlement offer and you go to arbitration and you end up doing better in the arbitration, even if it's a $10 arbitration dispute, you automatically get $7,500 and you get double the attorney's fees. So every party that has a claim should have more than enough incentive to bring that claim to AT&T's attention. And indeed, they go even further than that. They say that all the costs of arbitration will be borne by AT&T. The AAA rules will apply. The venue is favorable. I mean, all of the provisions are extremely favorable. Again, this will be a point of full disclosure. I had exactly the same issue coming out of exactly the same court 2 terms ago, but I will confess that our arbitration agreement was substantially less favorable to the consumers than AT&T's. And AT&T filed an amicus brief in opposition to that cert petition, in which it said, don't take Phillips's case, wait until AT&T shows up with its much better. Now, I'm not bitter about this.
I have to say, that issue has been around for a long time also, because your cert petition a couple years ago built on various circuit opinions and all, so it's,
Oh, it was cert-worthy.
yeah.
So again, the interesting thing again about this case now is that you've got both the express and the implied preemption issue embedded in here. They've got an express preemption provision, their interpretation of save as, and their argument is that this is not really classic unconscionability. They've rejiggered unconscionability in a way that makes it very arbitration specific, and therefore it shouldn't serve as a basis for falling within the exception. And then they say, and beyond that, if you allow this to go forward under these circumstances, you will clearly frustrate the whole purpose of this, because no employer, at least none that is ever thinks it's likely to end up or seller of service, or anybody who wants to have an arbitration clause is going to do it in California, so long as this rule is out there. And obviously, it is also a rule that could spread to all of the other 50 states. And so that will be the interesting divide, see how Justice Thomas comes out on it. This case, I have to say, these issues have always worried me, because by the plain language of the exception, this is a state law rule, unconscionability, that's been out there, and it'll be interesting to see precisely how the court plays with it.
Thanks. I didn't mention Carter's kind of bio when he first started speaking. He's the head of the Supreme Court practice at Sidley and Austin, and in many ways is really viewed as one of the deans of the Supreme Court bar, has been at it and has more arguments than most, I have to say, having been with him and against him. It's always a pleasure to work with him. We're turning away from preemption now, but as you can see, it's something that cuts across so many areas, and really one to keep your eye on. We're going to go back to an area specific with Glen. Glen is a partner at Jones Day, and he's head of the Issues and Appeals section there. And Glen does a wide area of topics and a wide practice. He was on the panel just before this, but one of the areas in which Glen is particularly known is in employment and labor, and he's going to talk to us about a couple cases there.
There are three employment law cases that the court has on its docket already, and given the time, I'm going to cover them each relatively briefly. The first is the one that's in your materials stub versus Proctor Hospital. This is the so-called cat's paw case. This case is a second-generation grant. The first-generation grant was the case that Tommy had, I don't remember how many years ago, now 3 years ago, the BCI COLA case, where the federal circuits have been split. And the issue that they've been split on is, in making an employment decision, assume that the person who makes the decision is as pure as the driven snow. No discriminatory bias whatsoever. What happens, however, if that person gets information from someone who is biased or is triggered to evaluate a situation by someone who is biased? In what circumstances would the employer be liable under a federal employment discrimination statute such as Title VII and the Federal Age Discrimination Act for making an illegal employment decision, even though the decision maker themselves was not motivated by race, sex, military status, etc. The cat's paw circuits, the Fourth Circuit and the Seventh Circuit, relying upon a fable, I'm not exactly sure, 17th century French poet. I was always wondering what it was, and actually the explanation for the cat's paw term is set out at the beginning of the Seventh Circuit decision in this case. The other thing that was interesting about it is my youngest daughter, who's 20 now, has often described my older daughter, who's 22's boyfriend, as a tool, and it also explains what a tool is. So you got a twofer here.
This is a classic source of American law, 17th century French fables.
And the Fourth Circuit and the Seventh Circuit have basically said that unless the decision maker was the cat's paw of the person who had the biased information, there's no liability. I'm sorry?
Which means what? What is it to be
Which
the cat's
means
paw?
that they were essentially rubber stamping someone else's actions. I mean, you can imagine the variety of ways this could happen. For example, an employer may get a reference from someone even outside the company that was motivated by bias, a bad reference. Can the employer be liable in those circumstances? The employer may get input from another employee who is the tattletale on the employee who's disciplined or terminated or the like. And what these two circuits have said is that the statute prohibits adverse employment actions based upon these protected criteria, and when the decision maker is not biased, there's no liability unless that decision maker was the cat's paw of the biased person, that they were simply rubber stamping the other person's decision and not exercising any independent judgment whatsoever. The petitioner in this case, the employee's argument is that liability is proper under the statute whenever an adverse employment action is causally related to the bias of a individual who is an agent of the employer, to try to exclude the reference check cases, and makes the very, I think, powerful point that the statute doesn't say anything about cat's paw. What it says is that the employer is responsible for the discriminatory actions of its agents, and whether the final decision maker is biased or not, if an agent was biased and thus influenced the ultimate outcome, then the employer should be liable under the statute. The employer in the case, interestingly enough, is not really defending the standard that has been used by the Fourth and Seventh Circuits, but is arguing pretty much factually in the circumstances of this case that the two individuals who were alleged to be biased, which were not the final decision maker, really didn't have any causal influence on the actual employment decision. And then I have to disclose I wrote the Chamber of Commerce's brief in the case. We have not defended the Seventh Circuit or the Fourth Circuit's decision, but we have made the point that the statute, all of these statutes embrace common law causation principles, which include proximate causation principles, and the point of proximate causation is not to test whether or not there was some kind of link, factual link between the alleged bias and the ultimate outcome. The point of proximate causation is to say at some point the bias is sufficiently attenuated from a reasonable, fair-minded human resources system that liability should not be allowed. Not making any predictions about how the court decides the case, but that's what the issue is. The second case that's on the docket is a case called Thompson versus Northern American Stainless, and this is to address the question of so-called third-party retaliation. Basically, the facts in the case are as the employer takes an adverse action against Tommy by firing Tommy's wife.
Thanks.
I'm not
Man.
Tom's wife, but
We just take out the whole family. Thanks a lot.
And Tommy's wife, who got fired, is very upset about that because she lost her job, so she files an EEOC charge claiming that the employer unlawfully retaliated against Tommy by firing Tommy's wife, me. And
We live in California.
Me, the wife, files the charge and then files a lawsuit against the employer, and the case presents the question, two questions really. Does the anti-retaliation provision in the statute apply to protect against third-party retaliation, and then does the third party have standing, the cause of action, to bring the lawsuit? The first question, I think, is a fairly self-evident one, particularly because of the Supreme Court's Burlington Northern decision, where Justice Breyer wrote the opinion and said that basically any act of the employer that might reasonably dissuade an employee from complaining can constitute unlawful retaliation. And certainly there's a long history in the labor laws and otherwise of documented cases of employers trying to retaliate against Tommy by taking action against his wife. So probably the more interesting question in the case is whether or not Tommy has to bring that case or his wife has to bring that case. And Section 706 F1 of Title VII says any aggrieved person may bring civil suit, and there's a long history and tradition of when Congress uses the term aggrieved person of construing it very broadly. So my guess is that the court will say that this is a proper lawsuit for Tommy's wife to bring, but we don't know. The last case is the most interesting one of the employment cases, and you won't think so until I get to the end of the story.
Well, we have to do it in a minute or two.
I'll do it in a minute or two. The question is whether or not the anti-retaliation provisions of the Fair Labor Standards Act apply to oral complaints made by an employee. The statute says that it's unlawful to discriminate against an employee because such employee has, quote, filed any complaint or instituted or caused to be instituted any proceeding. And all of the courts have generally said that, I shouldn't say all of the courts, many courts have said that this isn't limited to going to court or going to the government. It can apply to internal complaints within the employer as well as external complaints. And some courts, in this case, what the question, the Court of Appeals didn't question that. What it said, however, is that the issues would oral complaints suffice, or does it have to be a written complaint to the employer? And when in doubt, the employer in this case went to the most troglodyte of the Supreme Court bar to get counsel, sitting to my left. But obviously on my right philosophically, because Carter's brief says that the only complaints that would violate this particular provision of law are complaints made to the government, that only written complaints could be protected, and that any ambiguity in the statutory provision on either of those issues has to be resolved in the employer's favor because there are potential criminal penalties under this statute, and to show that he is just as extreme, in other words, just as principled as Justice Scalia, that he has argued that, and absolutely no deference is due to the governmental agency responsible for the administration of this statute.
And what's the name of that last case, Glenn?
That is Caston versus Saint-Gobain.
Saint-Gobain.
Right.
I'm not good
Yeah.
at French.
Glenn, you look lovely.
Well, that wraps up our business panel this morning, and thank you all for this great panel.